Good evening to all. Shall we start the session?
Good evening, ma'am.
Good evening, ma'am.
Voice is not audible.
Good evening, ma'am.
Good evening. Yes. Good evening, everyone. Today we have see the topic. It's a legal framework of company meetings from notice to resolution. Before start, just imagine a company taking a major decisions like appointing a director or approving a merger without informing stakeholders. Is it really fair? So would that decisions be valid? So today the sessions answer how the companies make decisions legally through properly conducted meetings. The understanding the legal framework of meetings. In these sessions, we will first understand the legal backbone of companies meeting as prescribed under the Companies Act 2013. In that act, it's a relevant secretarial standard is there, 1 and 2. So you will learn why the meetings are not just the formalities, but legally it's binding the corporate events where compliance is critical. Learn step by step meeting procedures also. We will then move systematically through the entire meeting process from issuing a valid notice, setting the agenda, quorum requirements, conduct of meetings, how the voting methods will be taken place, and finally drafting and recording that resolutions. That is called MOM. Yes, meeting of the minutes. Everything we are going to see these sessions. Okay. Then what is a company meeting? A company meeting refers to a lawful and formal assembly of members, directors, or stakeholders of a company. It's conveyed in accordance, it's with the provisions of the Companies Act 2013, the company articles of associations, and applicable secretarial standards. One second, sorry. I'm not little bit feeling well. Anyway, my voice is audible now. It's a little bit understanding now. It's not a problem for you, right?
No problem.
No problem, ma'am. You can understand.
Yes, thank you, John. Thank you, thank you. Yes. Then, lawful assembly of members. The team lawful is very important. A gathering becomes a company meeting only when it satisfies the legal requirements, such as proper authority to convey the meeting, then issue of valid notice, then the presence of the required members, that is quorum, then conduct of the meeting of the statutory procedures. So in any of these elements are missing, the decisions taken as such a gathering may be invalid, right? So it's it's a challengeable. So therefore, the company meeting is not on informal decisions, but it's a legally recognized forum. Secondly, discuss and decide company matters. The company meeting serve as the decisions making platform of the organizations. The matters such as that it's approval of financial statement, appointment, and even that terminate some auditors, directors, secretaries, like that. Then declaration of dividends, discussion about their uh, mm, financial statement, then strategic decisions like merger, some borrowings, then declaration of it's a policy approvals, like that. So these are the matters are discussed, debated, and that's finalizing there through resolution passed in that meeting. So these resolutions is reflecting the collective will of stakeholders, especially the directors, and become binding on the company. Then ensuring the corporate governance. The company meetings, it's a play a vital role in corporate governance by ensuring its transparency, accountability, participation, and compliance. So these it's through the structured meetings, the companies avoid the arbitrary decisions. So it's promote the ethical, responsible, and lawful management. So in essence of a company meeting is the legal heart of the corporate decision making, where that its authority, responsibility, and governance, it's in to guide the company's actions. Then what is the objectives of the company meeting? One of the primary objective of the company meeting is collective decision making. So it is important the managerial and strategic decisions such as approval of accounts, appointment of directors, declaration of dividends, it's a major policy decisions, are taken through it's a resolution passed in meeting. So one of the major objective is here collection of decision making at a single forum. Second objective is shareholders participations. The company meeting, it's provide a formal platform for stakeholders, it's even the shareholders also to participate in the meeting of the company. So through the meeting, the shareholders receive the information about the company performance, raise the questions, and some queries, seeking some clarifications, then exercise their voting right on the key matters. So this participation, it strengthen the shareholders democracy and ensure that the owners of the company have a voice in the how it is governed. Then third one is transparency. The transparency is achieved when the company openly discloses the information to its members during the meetings. The presentation of the financial statements, the directors report, auditors report, it's an explanatory statement. It helps the stakeholders to understand the company financial health, management decisions, and future plans, then risk and challenges faced by the organizations. So the regular and well conducted meetings, they promote the trust between management and stakeholders. Then finally, it's a legal compliance. Company meeting or a statutory requirements under the Companies Act 1913. It's conducting the meeting as a prescribed, ensure it's compliant with legal provisions, validity of decisions taken, even that protection of the company from penalties with litigations also. So the non-compliance such as it's a failure to hold meeting or improper procedures can attract the legal consequences for both the companies and its officer. So thus the company meeting are not mere formalities, they are essential the governance mechanisms that integrate the decision making, even the participations, transparency, and legal compliance in government, it's a corporate functioning. Then what are what are the types of company meeting is there? Because the company meeting, or broadly it's classified based on who participates and the purpose they serve. Okay, so the each type of meeting has distinct legal requirements and governance roles. I hope that everybody's or remember that the last week I just told that if the next week getting their same topic na the same courses, definitely I'm just to be explained in depthly in the meetings, because the meeting part is most important to come normally, take their company law courses, lot of topics, for example company formations, and what is that contract. Yes, everything, it's the legal related statutory things, everything we can't able to perform, we can't able to doing right, because some of the secretary, even it's a law knowledge is needed. I mean, the lawyers only just to take care of their entire things. Even our management students can't to able to do all the things. But anyway, if meeting, for example, after completion of your MBA, many peoples are going to start your own business, definitely that time you need their meeting, right? If everybody's, we are thinking like that, the meeting means two or more persons join together to discuss something, that is meeting. It's not like that. Meeting having lot of procedure is there. So in this sections, it's helpful for you for understanding all the things in depthly and step by step. Okay, so that's why I'm taking their entire section of the meeting. Okay, first you just to be understand the types of the meeting, then we can go for that what are all the types of I mean what types of meetings now we can just to be doing, we can follow their same procedures only. Okay, so first we can see the stakeholders meeting. So the name itself we can understand, right? The stakeholders meeting means it's a meeting that the members of the company, right? So the meetings are, it's a crucial because the shareholders exercise unlimited control over the companies. So the key features of that stakeholders, I mean shareholders meeting, na, it's include annual general meeting and extraordinary general meeting. Even the statutorily, it's governed by the Companies Act 2013 and Secretarial Standard 2. So used to approve the financial statement, the appointment or removal directors and auditors to declare the dividends and approve the major corporate actions. So these meetings ensure the stakeholders' democracy and accountability of the board of the owners of the company. Second, board meetings. Board meetings or the meetings, it's of the board of directors, the meeting of the board of directors. So who are responsible for managing the company affairs? The key features of the meeting is it's governed by uh, it's a secretarial standard 1. Okay, so it's focused on strategic decisions, form policy formulation, then approval of the budgets, borrowing, investment, and operational matters. So the directors, it's act in a, it's a fiduciary capacity, then making the decisions in the best interest of the company. The board meeting or the core executive decision making, I mean making forum of the company. Then committee meeting, the committee meeting or the meeting, or it's a specialized committee formed by the board to handle the specific area. For example, audit committee. Yes, the audit committee meeting now only they discuss about their what are the audit we just be taken place. Yes, when they are going to taken place, who are all that members, that is auditing the committee, especially the auditing related matters, what are the checklists, that much of matters discussed in the audit committee meeting. For example, if you go for a remuneration committee meeting only discuss about their remuneration part. Yes, then stakeholders relationship meeting. yes, the what are the stakeholders is there, how what are the relationship, yes, what is their bonding, yes, because for example convertible stakeholders are there, non-convertible shareholders are there. So what is the limit of convertible shareholders, what is the limit of non-convertible stakeholders, yes, then participative stakeholders, non-participative stakeholders, the stakeholders, the preference shareholders having their eight varieties, eight cadre. So each cadres, yes, what are the limit, yes, everything we can discuss in that shareholders relationship meeting. Then it's a CSR committee meeting, corporate social responsibility committee is there. In that committees, how we can go for that, how much amount per year we want to spend with the CSR, because CSR is most important nowadays. And because it's a brand name also, it's directly, it's just coordinate, it's relevant to the company. So CSR committee related things, everything we have discussed in that committee meeting. So committee having different committees, so each committee is the purpose of the committees, we can see that it's a committee meeting. Okay, then what is the feature of this committee? Now it's a focused decisions and expert oversights. Then it's improve the efficiency by delegating the complex matters like that. Then it's finally it's a creditors meeting. The creditors meeting involve the creditors of the companies, usually governed in special situations. What are the key features of creditors meeting? It's called during the compromise, arrangement, restructuring, or wind up. That much of related things we have discussed in the creditors meeting. Then conducted under the supervision of it's tribunals or court, then enable the creditors to approve or reject the proposal schemes. So these meeting, it's protect the the creditors interest and ensure the fairness during the financial restructuring or process also. So each type of company meeting, it's serve a distinct governance purpose. It's collectively ensuring lawful decision making, accountability, and stakeholders protection within the corporate framework. We can elaborately to discuss the shareholders meeting. The shareholders meeting or the meeting of the members of the company who are actual owners. Okay, so the equity shareholders means it is the owner of the company, very well, right. So this meeting, it's provide a statutory platform for stakeholders to exercise the control, approve the key decisions, and ensure the accountability or management. Under that shareholders meeting, mainly we having three meetings. First one is annual general meeting. The name itself, it's explaining their purpose of the meeting. Yes, the duration of the meeting also. Yes, when the meeting is conducted, because annual general meeting only once in a year. Okay, but every years we must to conduct a meeting. The annual general meeting is a mandatory meeting, right? Because the last year week also we have see that we just to be discussed regarding that, right? So what is the key point to explain? Because that oh, my voice is breaking. I don't know. I checked that my networks also. Everything is fine. My voice is breaking, ma. Now it's okay.
It's okay, ma'am.
Okay, ma'am. Okay.
Okay, actually, Pallavi, it's posted that, ma'am, your voice is breaking. That's why I'm asking that. Now, the Pallavi, is it fine for my voice?
Yes, ma'am.
Yes. Thank you, Pallavi. Yes. Um, we can see that now what is the key point of annual general meeting, because the annual general meeting, it's a serve as a forum where the board report to stakeholders on the company performance, example statutory matters, such as adoption of financial statement, declaration of dividends, then appointment or reappointment of directors, appointment of auditors are discussed and approved for this meeting. Which meeting? Annual general meeting. So the meeting must be held with the prescribed time limit under the Companies Act 2013. The AGM, the annual general meeting, reinforce accountability and transparency. As stakeholders, it's review the past performance and it's a question managed decisions. Then if you go for extraordinary general meeting, the extraordinary general meeting, it's conveyed, it's to discuss urgent or special matters that cannot wait until the next annual general meeting. So what is the key point here to highlight na? It is the extraordinary general meeting when immediate stakeholders approval is required, then deals with such a matters to alternative of it's memorandum of articles of associations, then it's approval of merger acquisitions, then issue of shares or debentures, removal of directors, the same agenda only, but we can't wait until that next AGM. So we can form that meeting na emergency purpose, that is extraordinary general meeting. And then class meetings. Class meeting, lot of classes is there. For example, in shareholders also 8 classes is there. So each stakeholders we are possible to giving their separate meeting. It's avoiding some confusions and bias also. For example, preference shareholders, non-preference shareholders are there. Preference shareholders means we are giving their, during the time of dividends, we are giving their first preference given to them. Okay, but we are generally to conduct their meeting from preference stakeholders and non-preference stakeholders. Now definitely they are getting some upset and confusion also. So that purpose only the class meeting, each class separately to discuss some matters, right? So that much of meeting is class meeting. Example, equity shareholders meeting, debentures shareholders meeting in a separate form. So what is the key point to explain here? Here to explain the convened when rights, what is their rights? Yes, what is their limitations? What is the record for what we are expecting from them, then variation of class rights, then it's a conversation of shares, what are the option is there, then what is the changes in dividends or what is their voting rights. So the class meeting, it's a protect the it's a minority and class specific interest. During that, no group of shareholders is unfairly disadvantaged. So together AGM, EGM and the class meetings, it ensure that the stakeholders it's remaining actively involved in governance. It's balancing, it's a route, it's a routine oversight way with the flexibility for urgent and class specific decisions. Then if you take that board meeting na, the board meeting or meeting, it's conducted by the board of directors, so who are entrusted with the management and control of the company affairs. So unlike stakeholders, the directors are responsible for day-to-day governance and long-term strategy, right? So that's why we are conducting their board meeting. First, it's conducted by directors. The board meetings are attended by directors of the company who act in a, it's a act in good faith, the exercise due care and diligence, then it's a make the decisions in the best interest of the company and the stakeholders. So these meetings, it's enable the directors to collectively deliberate and decide on matters within their authority. Then it's a minimum 4 meetings per year as per the section 173. Yes, as per the section 173 of the Companies Act 2013, every company is required to hold a minimum of 4 board meeting in a calendar year. So with a prescribed maximum gap between two meetings. So here what is the key point now? It's ensure the regular oversight and monitoring. It's a prevent the concentration of powers in few individual, then promote the continuity in decision making and compliance. So the failure to meet these requirements can result in penalties for the companies and its officer. Then strategic and operational decisions. The board meetings, it serve as a primary forum for strategic and operational decision making. Example, it's include the approval of business plan and budget, then it's borrowing the investment and financial policies, then appointment of key managerial personnel. It's a review of performance and risk management. So that board meeting, it's a bridge between the strategic formulation and executions. It's ensuring the company move into a planned and legally it's a compliant manner. So we can summarize now. So the board meeting or the executive nerve center of the company. It's ensuring informed decision making, effective supervisions, and strong corporate governance. Now we can see how we can conduct the meeting. What is the procedure? Is that the first step of the meeting procedure is notice of the meeting. The notice of the meeting is a formal and mandatory communication informing the member or director about the upcoming meeting. It is the starting point of a valid meeting, as no meeting can be legally conducted without proper notice. Please note of it, without proper notice, any one meetings conducted na, that is illegal. It's not to taken as a calculated, it is a legal meeting. It is not considered as a legal meeting. It is a informal meeting without proper notice, right? So if you just conduct a meeting now, whatever may be extraordinary general meeting, annual general meeting, board meeting, class meeting, whatever meeting, the first step, you want to be informed to the particular stakeholders through notice. Okay, otherwise that meeting is not valid. Okay, so if you take that AGM or EGM meeting now, 21 days clear days is needed. What is the meaning of clear days? Because the clear days means the Companies Act 2013, it's required minimum, it's mentioned that minimum 21 clear days. So the clear days means the day of sending the notice and the day of the meeting or executed na, we just to be, it's we just to be eliminated, we want to be calculated. Okay, so that in between definitely we need their 21 days. That is the meaning of clear days. Okay, so the objective is to give the shareholders adequate time to read the agenda. Why we just to be shared well in advance? Because they want to be read the agenda, then understand the issues, yes, then decide how to vote or appoint the proxies. So this ensure the fair participation and informed decision making by the stakeholders. Proxy is nothing. For example, I can't able to attend the meeting, so in behalf of me, I am just to be appointed one more person. That person name is called proxy. The proxies, I can possible to give the rights to the proxies behalf of me to go for voting, right? So that is called proxy. Second one is in board meeting. Yes, it's enough for 7 days. In board meeting, a minimum 7 days notice must be given to every director, because in that board meeting, no one's people or only the equity shareholders. Yes, we can say now it's a board of directors. The equity shareholders only to be participated. So the director is minimum level only. Yes, maybe the company's max minimum to maximum, yes, it's 7. So that we can call as that director. So only director should be participate that meeting, the board meeting. So we can say that it's enough for 7 days. Okay, because it is something in the narrow group, small group only. Yes, to compare the AGM, to compare the EGM, na, the here that minimum of members only participate. Minimum of members means only the directors only participate in the board meeting. So it's enough for 7 days. That is also, I'm not saying it is ensure the company's law. Okay, 2013. Okay, so what about the previous in the old companies law act year? Anyone, did you aware about that? Because the last week I mentioned that normally the Companies Act 1956. Okay, so after that very long period only, then it was revised in the year of 2013. Okay, I was studied in MBA. I was just to be studied all the legislation in the year of all the section in the year of 1956 only. Okay, after 2013 it was revised, but normally it was implemented in the effect, it's implemented in the 2014 onwards. Okay, fine. So the board meetings, a minimum 7 days notice must be given to every director. Then what is the key emphasis of this? It's enable the director to prepare for discussions, allow the review of documents, proposal and financial data, ensure effective and meaningful deliberations. So in urgent cases, the shorter notice may be allowed, but statutory conditions must be fulfilled. Sometimes in very urgent basis, in board meeting, we can allow the shorter notice also. Minimum 1 day, yes, prior, that is also allowed. But anyway, that is also the statutory conditions may be fulfilled. Okay, then third one is include the agenda and explanatory statement. Definitely in that valid notice, clearly mention that date, time and place, okay, of the meeting. Second, the agenda items to be discussed. Third one is explanatory statement for special business, anything is needed. Then another thing is the explanatory statement explain, the nature and importance of the business, interest of directors or key managerial personnel, if any. Yes, this promote the transparency, prevent the surprise decisions, and it's a protect the stakeholders rights. So thus it's a notice of meeting is not merely formality, it is a legal safeguard ensuring the awareness, it's a preparedness and legitimately of corporate decisions. Then so now everyone should be understand what is the notice of meeting, right? Second one is quorum requirements. What is quorum? Here the quorum, it is means it's quorum, it's refer the minimum number of members or directors required to be present for the meeting. Yes, otherwise the meeting is invalid. Okay, one rule is there, the minimum of members is present for that meeting. Suppose that member is not there, that meeting is not considered. Okay, again we want to be postpone the meeting, again we want to be conduct the meeting for another 1 day. That is the meaning, right? So without quorum, no business can be transacted and any decisions taken or it's void, yes, and unenforceable. If in that meeting anything is happened, any resolution passed or any discussion is happened, that is void, right? I mean invalid. So what is the minimum members to validate a meeting? Because the concept of the quorum is ensure that the decisions are not taken by the very small people or unrepresentative groups. That is the purpose only the quorum should be involved. Then adequate participation is ensured. Then corporate democracy and fairness are maintained. The quorum act as a legal safeguard against arbitrary or unilateral decision making. If you take that AGM or EGM meeting, it depends on membership. For stakeholders meeting, the quorum, its record depends on the total number of members of the company. Here the key explanation is smaller company record fewer member to the it's a form quorum. Larger company require higher members presence. So this flexible approach ensure the reasonable representation while keeping the meeting practically feasible. If quorum is not present, the meeting must be adjourned as it's statutory provisions. Normally, what is the rule now? A quorum means it's 1/3 of the total strength. Okay, for example, 900 stakeholders are there na, minimum need for 300. Yes, less than 300 means that meeting is void, I mean invalid. That is the meaning. For example, in board meeting, yes, 1/3 or 2 directors. Yes, normally, yes, which is higher? For example, in some of the companies only 2 directors are there. Yes, so definitely the 2 directors want to be participate in the board meeting. For example, 3 members are there. Yes, so minimum 2 directors or 1/3. 1/3 means it's only 1 directors. Yes, which is higher? Definitely 2 director is higher. So here the quorum is 2. That in that cases you can't say that like that 1/3 na. So if, quorum is normally the applicable for 1/3. So 1 directors is enough. No, it is invalid. That's why here mentioned that 1/3 or 2 directors only for the board meetings. Okay, because the directors counting is minimal. So that's why here the quorum is 1/3 or 2 directors, which is higher, that is quorum. Okay, here which meeting? Board meetings. Okay, it's ensure collective decision making by the board. It's prevent the domination by the single directors. So that purpose only the quorum is applicable for the board of directors. So only the directors present at the meeting are counted for quorum, and interested directors may be excluded for specific, something is agenda, it's items, right? So that is, then in summary we can say that is a quorum is the foundation of a valid meeting. So ensuring legitimacy, present representations and legal compliance in it's a corporate decision making. Then next one is one second. Okay. Then a resolution, the resolution, it's, if we take their formal decisions, it's taken by the company. It's duly converted. What are the resolution is there na? The resolution having 2 types. One is formal, ordinary resolution. Second one is special resolutions. The resolution is nothing, it is a formal decisions taken by the company. That's it. Okay, but how the formally to taken their decisions? Definitely they need their some confirmation. The next slide we can see that what are the confirmation, how we can consider. Okay, now we can see the ordinary resolution na. It's passed when the vote in, it's cast in favor, exit the vote, it's cast, it's against the proposal. For example, it's record the simple majority more than 50%, used for routine and regular business matters. So example, adoption of financial statement, appointment of redirectors, then appointment of auditors, so declaration of dividends. These are the things we can consider as a, I mean, day to day functions of the company na, we can consider as a ordinary resolutions, right? But special resolution means the, it's a higher level of approval. Special resolution need for more than 75% of approval. They must be passed by not less than 75% of the voter. It's cast in favor. So it's a prior special notice and explanatory statement or record here used for, it's a major or fundamental challenges. Example, it's include alternative of MOM or articles of association. It's a memorandum of association, MOA. That means it's 6 classes. Okay, it's involved, right? Name classes, object classes, address classes, I mean the registered classes, like that, right? But articles of association means it is the internal management procedures. So if anything want to be changed, the alteration, definitely in that meeting we can pass the special resolutions. More than 75% of people want to be accept. Okay, another thing is change in company name, change in company address. Then it's a reduction of share capital or increase the share capital. These are the things comes under the special resolution. Ordinary resolution, previously I told, appoint new directors or terminate that new, I mean any one of the directors, auditors, like that. That is ordinary. It's a day to day functioning. We can declaration of dividends. It is ordinary matter. That is, and declaration of financial statement. This is ordinary resolution is enough. But ordinary resolution, it's enough for 50% of approval. Okay, but special resolution, it's need for 75% of approval. Then board of resolution. The board resolution is decision taken by board of directors and duly it's convenes the board meeting. The key points, approval of budget, the appointment of key managerial functions. These are the things comes under the board resolution. But board resolution, it is not a very important thing. What are the board meeting, the director should be resolute. That is board of their resolutions. Apart from that, nothing. Then okay, you can say that for example, how we can consider the more than 75% they were, I mean they are accepting or not. How we can consider? Because through voting methods. Because the voting is the process through which members express their approval or disapproval of resolution. It's placed before a meeting. So different voting method ensure fairness, inclusiveness and transparency. The first show of hands. Yes, in that meeting, maybe it's show of hands is the simplest and most traditional methods of voting also, right? If in parliament we can just to be hidden that, right? It's creating some voice in their bench. That is, we can consider. Yes, 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 we can in that parliament everything, right? In secretariat everything. So that is, we can consider their voting, right? Sometimes in show of hands, that is also acceptable. This is very traditional method. It is very simple method also. So each member present has one vote, so regardless of shareholding. Then it's a voting is visible and immediate also. We can understand that, right? So take that, I mean note it in that resolution is passed. So generally used for routine matters. Normally the show of hands, right? They will consider. Second, but here what is the limitation is there, does not reflect the actual voting power based on shareholders. In face name shake wise, okay, everybody's are shown. For example, in teachers asking that yes, how many students are really it's taking their for examination time, okay. The teachers are asking in front of students face to face indirectly how many students are really to studied, yes, like that, really just to study their today examinations. They are asking now, everybody's yes madam, because that name shake, because we can't just to be hesitate in front of faculties, right? Because they are holding their internal marks, maybe. So that is the, yes, these are the things. Maybe it's here, the original things, it's not to be come in transparency, maybe the hiding is possible, okay, for name shake wise. That is the limitation of this here. Second one is poll. Yes, the poll is a more accurate method of voting, because still, it's in that election process we are electing the politicians also, we can use that poll method, yes, when voting power of matters. So the here key point is the votes are counted based on the number of shares held, may be demanded by members of the chairpersons. It's in result now, it's truly represent the ownership interest, right? We can so the poll voting is preferred for importance or disputed resolution also, right? Then e-voting. E-voting means the electronic voting. It's allow the shareholders to vote the online also without being physically present. That option also available in the Companies Act 2013. Enhance the shareholders participation, especially for geographically dispersed members. Then it's a transparent, secure and time efficient also. It's e-voting reflect the digital transformation in corporate governance. Then proxy. Previously I told now, the proxy is a person appointed by a member to attend and vote on their behalf, okay. So that is proxy. The key points of the proxy now, it's a useful when members cannot attend personally. The proxy can vote only as per the instructions. Then the proxy does not have the rights to speak unless allowed. For example, in members now, actual members having their rights to speak, okay, no need to getting some approval everything. But in proxy na does not to speak until they won't get the approval. So this ensure the representation without physical presence. Then it's a postal ballot. That is also allow the members vote without attending a meeting, either through physical it's a ballot papers or electronic means. Then what is the key points here now? It's used for important resolution as prescribed by law, ensure the wider participation, everything. So different voting methods provide the flexibility and inclusiveness, ensuring that every eligible members can participate in corporate decisions making in a fair and lawful manner. Then more important thing is meeting of minutes of meeting. That is, the minutes of meeting or the official written record of the procedure, it's a proceedings and decisions. It's taken by duly convinced meeting. They serve as a authoritative account when it's a transpired, it's during the meeting. First one is official record, date, time and place of the meeting. Normally, what is the difference between agenda and minutes na? Agenda is, it's a pre-planning. Yes, what are the things going to happen? That is agenda, okay. Before conducting their meeting, we just to prepare the items. Yes, which date the meeting going to held, which place the meeting going to held, yes, what timing the meeting going to happen. So everything, yes, we before held the meeting now, we prepared and sent to the through notice. Okay, that is agenda. Meeting means it's a finally, yes, once the meeting is done now, we have prepared their records. Yes, when actually it was happened, what timing. For example, in agenda, maybe we have mentioned the timing, meeting time is at 10:30, but actually the meeting it's happened now 10:40 or 10:45 now, the exact timing it mentioned in the MOM. Okay, so these are the major difference between agenda and MOM. Okay, so in that official records, we just to be recorded the date, time, place of the meeting, summary of discussions, then confirmation of quorum, how many members were presented, name of the members, directors of the present, who is the chairman of the meeting. Yes, chairman means who is a chairperson, who is going to proceed the meeting, that is chairperson, chairman of the meeting, exact wording of resolution passed, everything they ensure their continuity, clarity and accountability, especially when management or directors change everything. Yes, we can officially record it, that is MOM. Then it's prepared within 30 days, right? After completion of the meeting, the meeting minutes, the meeting minutes will be prepared within 30 days. We just to be circulate all the members. Okay, attendees, non-attendees, absentees also, we want to be share the MOM, because they want to be understand what happened in that meeting. Okay, that is the purpose of meeting minutes. It is the record, it is a future reference. Okay, so minutes must be prepared, finalized and entered in the minutes books within 30 days of the meeting. Okay, another thing is that it is a legal evidence. The minutes are recognized as legal evidence. Okay, in court, and regulatory proceedings. So what is the key point here now? They prove that the meeting was lawful, convinced, then it's a valid decisions, like that. Then finally go for yes, one second. Finally we go for conclusions. It's a well conducted company meetings or the foundation of effective corporate governance. Okay, when the meeting or it's a properly convinced na conducted and documented in accordance with law, and they ensure now, first one is transparency. The meeting promote the transparency by open communicating information to stakeholders and directors, proper notice, clear agenda. Why we are giving their agenda in within well in advance for 21 clear days, everything, because they want to be prepared. Yes, they want to be any clarification, they want to be execute, they want to be proceed in that meeting. So everything in the transparency. Second, accountability. Through the structural meeting, the directors and management become the answerable. Yes, any stakeholders in that meeting now, to given that opportunity, it is one of the opportunities, because the management want to be answerable. So the meeting it is the accountability. So that's why the meeting will be happen. Then legal validity. Another thing is not only transparency, not only accountability, it's a legal validity also, because that the compliance with statutory procedures such as quorum, voting, resolutions and minutes, everything, it's a legal legitimacy. Okay, so to corporate decisions, so the well conducted meeting protect the company and its officers from dispute, penalties and legislation. So in essence, the company meetings are not mere formalities. Okay, they are legal instruments that uphold transparency, accountability and lawful decisions. Okay, but anyway, I hope that everyone should understand what is that importance of the meeting. The meeting means it's not just like that to immediately to just to be gather the people to share that information, right? That is informal meeting. Formal meeting means definitely well in advance want to be intimate, then properly share their items, yes, itinerary items, yes, then formally we take their decisions, right? Then the minutes should be recorded. At least the basic 4 or 5 items you should understand. It's helpful for your, because in future many of them going to serve as a manager, I mean leadership role. Many of them serve as a, I mean to start your own companies, right? So the meeting is a basic things. At least you want to be follow these things. Okay, or you got it, ma? At least satisfaction purpose, 2 to 3 people, please unmute and share something. Yes, madam, got it. At least having any doubt.
Yes, ma'am, got it.
Thank you, Hari
Got it,
Krishna.
madam. Good.
Thank you.
Yes,
Because
ma'am.
now I just to be understand everyone's or listen the classes or all are just to sleeping. How I understand the assessment is most important. Na? Another thing is that teacher satisfactions only to getting their yes feedback from your side, right? That's why it's motivating the teachers for that next class for eagerly to preparing their innovative materials and just to innovative strategy how we can go for that next classes, everything, right? Okay, thank
Yes,
you
Your
so much.
explanation was good, ma'am.
Okay, thank you. I feel like that it is formality basis you sharing their feedbacks. Okay, thank you. Yes, now we are going to leave the sessions. No, okay, because the assessment part is pending. Okay, I want to be understand how much of the students eagerly to listen my classes. Okay, so small based questions. Okay,
Ma'am,
it's a
before
it's a
that,
one word
can I
question.
get one clarification?
Yeah, please,
Yeah.
please.
Yeah, as we discussed a notice of a clear meeting, there is a 21 days clear days, right, for the AGM and EGM.
EGM.
Is it the calendar days or is it is the 21 working days?
No, not like that. It is a calendar based.
Okay, thank
Yes. Then any clarification, ma? We can go for that question na. It is only one word questions. Okay, so what is the minimum notice period for the AGM?
21 days.
21
you.
clear
21
days.
days.
Very good. Yes, second, who can attend and conduct a board meeting?
Board members.
Board director,
Directors of the company, right? Good. Then what happen if a meeting is held without quorum?
It's not valid. Not
Not
legally
valid.
Yes,
valid.
it is invalid. The meeting is
Not valid.
invalid.
formal.
Very good. Then, which resolution required 75% approval?
Special resolution,
Special resolution. Ordinary resolution, it's enough for
50%.
50%. Good. Then, okay, it is very chilly questions, very simple questions only, but these questions it's helpful for remind the matter. Okay, remember the things. What are the contents we discussed? Apart from that, nothing. Okay, so don't think that everything it's a very chilly questions. Okay, it's only for remembrance. Okay, then next, what is the name any one of voting method? Any one of the
Poll,
voting methods?
poll voting.
E-voting,
Polling.
Poll voting.
Poll,
Hand
then
showing.
digital
Post
voting,
ballot.
E-voting.
For hands.
is e-voting,
Oh,
then
friend.
Proxy.
show of hands,
ballot,
postal ballot, then
Proxy.
Yes, very good, very good. Yes. Then if an urgent decision is required before the AGM, which meeting should be called?
EGM.
Yes,
EGM.
extraordinary general meeting. Good. If your shareholders cannot attend a meeting, how can they still vote?
E-voting.
Proxy
E-vote.
or e-vote.
Proxy, e-vote,
E-vote.
postal.
Full board.
Right?
Yes.
Yes, good. How many board meetings are, it's mandatory in a year?
Four.
Four.
Four. Yes. Which sections is derived for this? Did you remember that section
Section 170.
173? Right? Section 173 as per
Yeah.
the norms. Yes, the Companies Act 13. Yes, the board meeting is mandatory 4 per year. Okay, good. Then in which meeting or financial statement approved?
AGM.
AGM.
AGM. Good. Then or resolution passed without voting, it's legally valid? Yes or no?
No.
Hmm.
No.
No.
Voting is essential for
Correct.
validity, right?
Yes.
Good. Then if shareholders, it's want to change the company name, which resolution is required? Change the
Special
company name.
resolution.
Special.
Special resolution.
Special
Yes,
resolution.
special
70%
resolution
approved.
is needed. Change the company name, change the MOA, Memorandum of Association, change the Articles of Association, change the register office, right? Good. Then, what about ordinary resolution?
This general changes. I mean,
Day-to-day
manager
operations
changes.
related, right? Good. Then, which meeting it's protect the rights of the specific class of the stakeholders? Which
Hmm.
meeting protect the rights of the specific class of the stakeholders? Name
Hmm.
itself is there, na?
Classmate.
Class
Class
meeting.
Class meeting.
Class meeting.
Yes, good. Okay.
Madam, one question.
Yeah, please.
Can you tell me about what is the delegation of authority? TOA.
Yes, delegation of authority means we just to be given authority one person to another person. Okay. For example, I'm the director of one institute. Okay. So my chairman delegating his authority to me. Okay, that is delegation of authority. That authority may be having some limited. For example, maybe signing authority, maybe voting authority, maybe decision authority, whatever may be. It's a delegation of
Company
authority.
delegation. Company delegation of authority.
That's why I'm saying that. Company
Yeah.
means what? It's not comes under that educational institute. It is the company law related. Delegation of authority means we just to be authority. For example, one person's want to serve as a posting, na? Maybe the teacher post or maybe accountant post or maybe auditor post or whatever may be. The posting is not matter. I mean the designation is not matter. We just to serve as a designation, na? We need the authority.
Got
Yes,
it.
we
Yeah.
need that authority means we need power. Okay, that power, where I'm just get the power, because some purpose, some persons to allocate the power to me. Okay, that is delegation of authority. It is the management concept. It's a 14 principle. It's one of the principle is delegation of authority. Okay.
Okay. Thank you. Clear.
Yes, okay. If any upcoming sections, do you have any concept want to be take? Not, I'm not asking that company law related. If anything, management related, anything, any topic, you tell me, I'm just to be take that.
Okay, ma'am. I will let you know.
Yeah, okay, fine. Okay, ma. Thank you so much. Yes, for your attendance as well as that cooperations. You don't have any doubts now. Please leave the sessions. Thank you.
Thank you, ma'am.
Thank you, ma'am. Thank you, ma'am.
Thank you, ma'am.
Welcome.
Thank you,
Have a
ma'am.
nice day.
Thank you, ma'am.
Thank you.